Yes, just make sure you speak loud and clear so our court reporter can get everything down.
Yes, Your Honor. Ladies and gentlemen of the jury, good afternoon. We already briefly met during jury selection, but allow me to introduce myself again to you. My name is Peter Venuti, and I, alongside my co-counsel, Ms. Jones, who you already heard from, we represent the accused in this case, Mr. Marcel Johnson, who sits before us all here today at the defense table next to Ms. Johnson, an innocent man. And why is that, members of the jury? Why is Marcel, as we call it, presumed to be innocent? Well, the answer to that question is actually quite simple. It's because our United States Constitution demands that of us, demands that of you, the jury. And the only way that changes is if you all collectively find the prosecution prove their case to you against Marcel beyond all of your reasonable doubts. Now, the prosecution, they're going to come up here and they're going to try to present evidence to show you that Marcel committed these crimes.
Okay, if you want to, Mr. Rennie, you can take the microphone out of that stand and you can hold it in your hand.
Yes, Your Honor.
Just make sure you speak into it so the court reporter can hear.
Yes, Your Honor. And members of the jury, should you find that evidence to be likely, you got to vote not guilty. Should you find that evidence to be very likely, your verdict must be not guilty. The prosecution's job in this case, members of the jury, is to prove guilt beyond all reasonable doubt. In other words, at the end of this trial, when all the evidence has been presented to you and all of the witnesses have testified, and you all go back to the jury room to deliberate about this case, if you just have one doubt in the back of your mind that's reasonable, that Marcel did not commit these crimes, your verdict must be not guilty. Now, ladies and gentlemen, you are going to hear a lot of things over the course of this trial. But the truth is, this case, it's not about what happened. We already know what happened. There was a tragic shooting in the middle of the street. A young man lost his life. Others were injured. And the person responsible should be held accountable. Absolutely. But members of the jury, this trial, it's not about emotion and it's not about tragedy. It is about evidence and it is about proof. And at the end of this trial, you'll see the evidence against Marcel simply does not prove that he participated in this shooting. Members of the jury, I anticipate that throughout this trial, you'll see no photographic or video surveillance evidence of Marcel in the vehicle the state's suggesting he was in at the time of the shooting. You'll see no forensic evidence of any kind found of Marcel's at or near the crime scene. No DNA, no fingerprints. No ballistic evidence tying Marcel to the firearm the state's suggesting was used in this case. No gunshot residue found on Marcel's clothes when they were collected. No firearm ever recovered by law enforcement in this case. None of that is going to be present throughout this trial. Why? Because it simply does not exist. And members of the jury, in terms of eyewitnesses, there are none. Zero. Not one person is going to be able to come up here, take the witness stand, and tell you that they saw Marcel at or near the crime scene during this shooting. Not one. All I'm asking you throughout this trial is to keep an open mind and hold the government to their heavy burden in this case. So, members of the jury, what evidence will you see? The state mentioned some of it during their opening. You'll see, as Mr. Garard pointed out, 10 months after this shooting, the gun that the state's suggesting was used in this case was used 10 months later in a separate shooting while Marcel is in jail arrested for this case. What does that tell us? It tells us that others had access to this firearm. It tells us that others actually used this firearm. And it tells us that the person responsible for this shooting is still out there. I believe Mr. Grell said, quote, "That gun is still out there being used by someone." Members of the jury, I would argue that someone is the person who committed the shooting in this case. What else is there in terms of evidence? What else might you see throughout this trial? Well, I anticipate that you're going to hear that early on in this investigation, there was another person of interest by the name of Mr. Thomas. Mr. Thomas became a person of interest because in proximity to the shooting on December 3rd, he posted something on social media. That post read, "If you think I did it, then I did it." And do you think the lead detective, in this case, Detective Mittling, conducted a formal interview with Mr. Thomas? You would think so, but the answer to that question is no, he did not. Members of the jury, it is an awesome power that the government has. But what each and every single one of you have is actually even more powerful. You all have the power to say no. In this courthouse, in this courtroom, in those very seats you're in, you all have the power of justice. And nothing is more powerful than that. So I ask that you all, and I know that you will, pay close attention throughout this trial. Take notes if you have to. Weigh the credibility of every witness who gets up on that stand and testifies. Hold the government to their heavy burden in this case. And members of the jury, if you can do that, I am confident that you will render a fair and just verdict for my client, Mr. Marcel Johnson, and the only verdict that matches the evidence in this case of not guilty. Thank you.
Thank you, Mr. Bernuti. All right. Members of the jury, same instruction I gave to the other jury. Can't discuss anything, including amongst yourselves. You'll retire to your jury room, and we'll bring you back out as soon as we can. All right, Mr. Gascon, opening statement on behalf of Mr. Garard.
Thank you, Your Honor. Please support.
Yes.
Counsel. Good afternoon. I know it's the end of 3 long days. We've all been here suffering through it. Mr. Garard has asked Ms. Jamison and I to represent him in this case. You've heard the indictment and the charges, and you've heard the opening statement of the state of Florida. What you haven't heard is the evidence that will come forward in this trial. And that's what we're here to talk to you about today. You've probably figured out that we don't agree with the state of Florida. We don't agree that the evidence shows that Kentrevious Garard did anything illegal on December 3rd, 2022, or had anything to do with the death of that young child. It was a terrible tragedy in Jacksonville the day that child died. But there is nothing the state can present to you that says Kentrevious Garard, beyond a reasonable doubt, had anything to do with it. You heard Mr. Grell talk about the cell phone. You're going to hear that his cell phone stayed home the entire time that this crime was supposed to have been committed. That it was not used. And then when it was not used for a good period of time, but then when it was used at his residence. And you're going to hear a police officer offer an opinion that, oh, well, people that are going to go commit crimes don't carry their phone. It's a case of damned if you do and damned if you don't. You carry your phone everywhere. Oh, we know he was there because he had his phone. Oh, we know he was there because he left his phone at home. That's not true, and that's not evidence, and that's not proof. And that's not what you're going to see in this case. You're not going to see any proof that he did that. What you are going to hear about is a foolish and terrible and tragic act on December 3rd. And you're going to hear that it was a foolish act of vengeance between adults that let their playground mentality spill over into gunfire. Mr. Grau talked about it. There was a history amongst some of these people. There was Marcel Johnson, there was Kobe Johnson, there was Emmanuel Pringle, there was Isaiah Pringle, there was Jalen McIntyre Burroughs, his brother, Marquise Holloway. All of these people, there was terrible bad blood between them. What name didn't you hear? That's not a name you're going to hear amongst all these bad blood people. The worst you're going to hear is that Kentrevious Garard was a friend of Mr. Johnson's at the time. They had been friends for a long time. They kind of grew up around each other. They knew each other from the neighborhood. Not unusual, not in our societies, not in our cultures. You'll hear this bad blood goes back to a barbershop shooting in 2019. And then there's a bunch of other small and different acts that go on, including the one Mr. Grau talked about with the physical beating of Kobe Johnson by Jalen McIntyre Burroughs and Marquise Holloway. And you're going to hear that there was a phone taken from Marcel Johnson, and on that phone was a picture of his beaten face. His constant reminder. He'd had it. He was ticked off. Done. I'm going to show them. And he did on December 3rd. He took it out on Jalen Burroughs because in Kobe Johnson's mind, Jalen Burroughs was responsible for what happened to him. He got Marquise Holloway there, and he got them, they beat him up. He held Jalen Burroughs responsible for that, Jalen McIntyre Burroughs responsible for that, and he wanted his revenge. And his brother got it. We've never denied since day one that Kentrevious Garard knew Marcel Johnson, or knew Emmanuel Pringle, or knew Isaiah Pringle or Kobe Pringle. But several of them went to school together. Some of them grew up together. They were friends. They crossed paths in the neighborhood. They did things together. Some things that we don't approve of. Smoking marijuana. Mr. Grau mentions the park that they went to near the apartments in the Brooklyn area of Jacksonville. Why was Kentrevious Garard up there? He was going to buy marijuana. His girlfriend was in town. She was staying with him at his mother's house. They were going to have a little party. They were going to smoke some marijuana. The evidence will also show that at one time, Marcel Johnson, earlier in 2022, had even lived with Kentrevious Garard. That's how close they were. But they had begun parting ways back in November when Marcel ignored Kentrevious' birthday. Kind of hurt his feelings. Showed him he wasn't as important to Marcel Johnson as Marcel Johnson was to him. They played games together. They did rap videos together. The state shows what they intend to show on these rap videos. Y'all are going to be introduced into a genre of music that I have absolutely no interest in nor knowledge of. And you heard one of the jurors talking about how demeaning it can be and how violent it appears because they have guns. It shows them in the background smoking what appears to be marijuana. We don't know if it is. Could have been. Might not have been. Don't know, but that's what it appears like. It shows all these things. That's what the evidence is going to show you. Did Kentrevious Garard do things wrong? Yeah. smoking marijuana in our society without permission from a doctor is illegal. Wrong. It's just as wrong as an 18-year-old drinking a beer. It's just as wrong as getting behind the wheel having had too much alcohol to drink. But it's not. It's not attempted. There's no evidence of attempted murder. This is paint with a broad brush, implicate everybody you can, and hope you get a conviction. That's what this is. Because this evidence isn't going to show anything that Mr. Garard did that day or any time around there that ties him to it. There are no witnesses that say Kentrevious Garard was in the passenger seat of that vehicle. It's not going to happen. And when Mr. Grau talks about fingerprint, the fingerprint could have been put there anytime. He said, it's no proof that he was in the car December 3rd. There's not even proof that he was in the car, because if it was on the window frame of the passenger car, he could have reached up there with his hand, leaning in, talking to somebody, or somebody else got in the car and he grabbed the door and pushed it shut. Fingers are there. No other fingerprints belonging to Kentrevious Garard. There was none on the dashboard. There was none on the handle to the door inside. None on the armrest. None on the center console or the seat. And then they want to tell you about DNA. Well, we sent the casings away, but he has a way of destroying DNA, which isn't untrue. It does. But just because his DNA wasn't there doesn't mean he wasn't there. That's the state's position. Now, if his DNA was in there, they'd be telling you, hey, this is proof that he was there. Another damned if you do, damned if you don't. It doesn't work that way, ladies and gentlemen. In a court of law, the rule is evidence, permissible evidence. It's got to be probative. It's got to prove what it tends to prove. We're not doing that. That presence of one fingerprint is what ties Kentrevious Garard to charge. That fingerprint inside a door frame on the passenger side of the vehicle is what ties him to that car. Any one of us could have left that fingerprint on any car. How many times have you walked someone to a car and shut the door for them? How many times have you walked by a car in a parking lot and without thinking about it, you lean or you stumble a little bit and you touch the car? Oh my God, there's your fingerprint. There may be touch DNA there. What if that car's used in a robbery? What if it's used in a killing? That's what the state's evidence is. It is so far removed from actual proof that it begs credibility. All it is. They are attempting to paint with the broad brush. And you heard Mr. Grau say, Kentrevious Garard was eventually arrested in Orlando. He had 3 phones. Is there an explanation? The state's not on that. His godmother had a plan that he had been included on. She was trying to get rid of that plan and just have herself on it. And she cut it. And he knew she was cutting it, and he went and got what I've always heard called a burner phone or a cheap prepaid phone. You get these phones on some cheap low plan. That's what you can afford at the time because you got $50 in your pocket and you get a phone and you call people you know to give the number. There's nothing wrong with that. There are segments in our society and our culture that that's the only phones they have access to. Then you hear, well, he was arrested in Orlando. But before that, you're going to hear, well, they looked for him in Georgia. It's terrible. You listen to that. You sound it out in your mind. Oh, after the shooting, he went to Georgia. Why would he do that? Guess what? He's got family. He's got a little sister that plays basketball up there that he goes up there frequently to watch play basketball because he and his family enjoy the fact that his sister is successful at that. And she gets great joy from them being there. It sounds terrible when you hear it. Oh, he was in Georgia. Here's another one. After Georgia, he went to New York. Oh my God, New York. It's as far away from here as you can get. Why in the world would anybody go to New York if they weren't guilty and running from the police? Guess what? Work for a company out of Jacksonville that's sending. He came back. He didn't stay up in New York. He didn't take a chance to get a bus or a plane or a train from New York and go out west somewhere. He came back to Jacksonville. He came back down south. Went to Georgia and saw family. Then, they arrested him in Orlando. They got a warrant. They were looking for him. They found him in Orlando. Guess what he was doing? He was working. Sounds terrible on the surface. Mr. Garard tells you this, sounds terrible. But when you look under it, you scratch that surface. What do you find? You find the truth. And the truth is he was down there working. They're going to play. They sent detectives down to Orlando to talk to him. The judge has told you all about all the rights and everything we all have, and he's talked about the Constitution and the Bill of Rights, and he's right. Haven't seen it, you got to go up there. National Archives, it's absolutely beautiful, and these things are there in those big glass enclosed boxes, and they're beautiful, and they inspire you. They make you respect what our forefathers and foremothers stood for. Freedom, justice. That Bill of Rights guarantees to him the right, and you the right, to not talk to the police. Don't have to. What did Kentrevious Garard do in the Orange County Jail? He talked to the police. He had nothing to hide. He talked to them. They're going to play for you a phone call that they recorded from the jail between Kentrevious Garard and his girlfriend, who had been visiting him in Jacksonville the weekend of the murder. And his whole goal that weekend was to spend as much time with her as he could. And they're going to make you think that that phone call is terribly incriminating. Stick with the plan. Do what I told you. As you might guess, everything has context around it that makes it more or less understandable. Without context, that phone call means nothing. What was the plan? Help find me a lawyer. Tell the truth. Is he guilty for telling her to do that? Does that make him guilty of a murder, an attempted murder? No, it doesn't. The other thing you'll find out about these young men, which I have some nephews and great-nephews that fit into this category, they play these video games. And when I was growing up, video games you played on your own TV or your own computer. Now they play them online. I might be playing with somebody that lives in Amsterdam or in San Diego, California, or around the corner. And the game that was their game of choice was Grand Theft Auto. And you're going to hear Emmanuel Pringle verify what he said in his deposition under oath, that when Kentrevious Garard said, sprayed that bitch up, he's talking about the game they were playing online. That's what Emmanuel Pringle's going to say. He said it under oath before. If he's changed his story, the evidence will show you that he's changed his story. So why is he changing his story? What's happened? Those are issues. Two searches of Mr. Garard's phone. One about the SIM card and the one about his friend in jail. I can tell you that in my business, being a criminal defense lawyer, if you were to check my phone, you would find many searches for people in jail. And they're not necessarily my friends. They could be co-defendants. They could be people that are going to testify against a client. They could be people that help put my client in jail. I'm wanting to find them, and I'm wanting to find out about it. Does that implicate me in it? And I'm so ignorant about electronics and the modern stuff that goes on that the last time, the only time I ever went out of the country, I had to search SIM cards because I didn't know what they were and what they did. But I knew I had to buy a new one when I got overseas. His was specific as to how do they track your phone without a SIM card. Okay. Does that make him a criminal? Does that make him guilty of murder or attempted murder? No. We're trying to stitch together enough little things that we throw enough of it at the wall, we're going to paint a picture for y'all that y'all can say, yeah, we can see that. But guess what we can see translates to in the legal world, in the courtroom? It translates to the same thing that maybe does, possibly does. It translates to not guilty. Because it's not proof beyond a reasonable doubt. It's supposition. It's a conglomeration of different issues put forward to make y'all think terrible things about Kentrevious Garard. This is a young man that sits here, as Mr. Venuti said, as the judge has told you, innocent. And the only people that can remove that innocence is y'all. And the state's going to try and get y'all to do it on sketchy evidence. Because, as you've heard many times this week, this is a high-profile case. It's a terrible thing. A young man lost his life. It is high-profile. I understand that. It would look good for the state. It would look good for the Jacksonville Sheriff's Office if they'd solved this crime.
Objection, argumentative.
Sustained. Its purpose of opening statement is to tell the jury what you expect the evidence to show, make arguments in closing.
I'm sorry, Your Honor.
You may proceed.
The evidence is going to show you that the Jacksonville Sheriff's Office can't produce any evidence, DNA from casings, from cars, from guns, that tie Kentrevious Garard to it. The evidence is going to show you that they can't produce any videos or photographs that put him in the car the day the shooting occurred. What it is going to show you is there is a burn mark inside passenger side door on the headliner right below the window, or the top edge of the window frame. Burn mark in the headliner. What is that consistent with? You're going to hear from the ET that did that, the evidence technician, that it looked burned to her. Firing guns cause burns on fabric? The evidence will show you it does. A person was sitting in that passenger seat pointing a gun out the window, it's not up here by the headliner. Guys on the other side of the car doing this, aiming up at an SUV from a little Rio sedan. Yeah, that's exactly what happened. There is nothing that ties Kentrevious Garard to this crime, other than he picked a friend that his mother would have probably preferred he not be around, because his friend got caught up in acts of vengeance and revenge, as Mr. Grau referred to it, dissing each other. You heard Mr. Garard tell you about the DNA evidence that they got from the car. It excluded, not included, excluded Kentrevious Garard altogether. Ladies and gentlemen, the evidence is going to leave y'all lacking for the reason to find Kentrevious Garard guilty. You're going to have to return an honest verdict. The judge has told you. And based on that evidence that the state has against Kentrevious Garard,